Hello, this is Anthony Parent of IRSmedic.com, and this may be the single most useful video we ever present. And we're going to explain to you why, if you are thinking about entering into some disclosure program because of some missing document overseas, if you're thinking about entering the U.S. tax system. I am an attorney, and I have been doing a lot of offshore work since 2009. And I want to tell you, it might not be your best call to contact me first. And there's some reasons why, and we'll get into those. And one of the things that bugged me from day one of this is that the IRS claimed that back in 2009, when the offshore disclosure storm started, it was really a one-size-fits-all sort of a penalty regime. So people who made innocent mistakes, they were getting penalized at 20%, 25%, 27.5% of their high account value. Incredibly inappropriate. And so a lot of people went ahead and did what is known as a quiet disclosure. Now, the IRS wasn't so happy with this. In fact, they identified 10,000 soft disclosures that they were going to examine. So I would often tell people on the phone, it's like, okay, you could do what you want. I'm not going to tell you what to do. This is the way that we're doing. And this is before the Streamlined programs came out. I'm not going to tell you how to do it. I'm just going to tell you that the IRS claims they're going to be coming after people for both who have done, and I actually have a screenshot of this. Let me show you this. The IRS said, and here is the original FAQ from 2009 that we're looking at. The IRS said this: the IRS is aware that some taxpayers have attempted so-called quiet disclosures by filing amended returns and paying any related tax and interest for previously unreported offshore income without otherwise notifying the IRS. Taxpayers who already made quiet disclosures may take advantage of the penalty framework applicable to voluntary disclosure requests regarding unreported offshore accounts and entities. Those taxpayers must send their previously submitted documents, including copies of amended returns, to their local CI office by September 23, 2009. Taxpayers are strongly encouraged to come forward under the voluntary disclosure practice to make timely, accurate, and complete disclosures. Those taxpayers making, and here's the point I want to make out here, those taxpayers making quiet disclosures should be aware of the risk of being examined and potentially criminally prosecuted for all applicable years. The IRS has identified and will continue to identify amended tax returns reporting increases in income. The IRS will be closely reviewing these returns to determine whether or not enforcement action is appropriate. This was something that I would tell to potential clients to say, look, if you're going to do something other than full disclosure, here's your real risk. That the IRS may actually criminally prosecute you and penalize you harsher, penalize you at 50% of those account values. Now, the strangest thing happened. Here is the IRS threats, and actually a year later, I was looking for this press release. They said they identified 10,000 soft disclosures, and they said they were going to go after him so incredibly hard, your heart would skip a beat. Now, what happened was the IRS did nothing. It was their bark. They claimed they were going to do that, but they didn't do that. And to me, that was a breach of trust. As a tax advisor, I am looking at what the IRS tells me as something that I should interpret and spread to my clients. However, it was the people who made the soft disclosures, the quiet disclosures. They did something the IRS didn't want to do, and many of them, it ended up being the right thing to do. So this is the background of what we're looking at. This is the background of what we're looking at. The IRS is scaring every practitioner into forcing their clients to make sure they do the harshest penalty possible. Now, years later in 2014, thankfully, the Streamlined Disclosure Program came out, and we were able to avoid penalties for people living overseas, and it was a 5% penalty for people in the US. But prior to that, it was a one-size-fits-all application that was incredibly unfair, and it was a threat that forced people to a higher penalty than that was appropriate. So with that as our background, and that is with that as our background, we're going to explain a little bit more why calling an attorney to talk about your offshore disclosure first might be a bad idea. With me today is John Richardson and Keith Redmond. Now, boy, we got two heavy hitters here. You know what? Why don't I start off with John Richardson, and he can he put an article 10 years ago, which could be the Bible, because you just recently updated it here. This is an article you wrote, Americans Abroad in the Compliance Dilemma. What should be considered before contacting a lawyer? This was originally written in July of 2013, and you updated it because you were going to write another one. Is that right, John?
No, I wasn't going to write another one at all. What happened was that last week I became aware of what I would call an advertorial or an infomercial from a tax compliance firm in Canada that it really reminded me of the situation in 2010 to 2012, which was clearly designed to play on the fear, the anxiety. It was clearly aimed at the large numbers of people who are U.S. citizens, never lived in the United States in some cases, and was designed to frighten them into, very interesting, the article said that they have to get, quote, proper U.S. legal advice. And I looked at that and my initial reaction was, well, yeah, okay, that makes sense. But then I thought a little more and I said, well, hang on a minute. What exactly is proper U.S. legal advice? And that's one of the things that I think we should talk about today. And also, I think, just do an update, I think, generally how to think about this whole problem. I would like to, before we get too deeply into this, after breakfast this morning, I looked at this again, and I just want to make a few point form suggestions here before we get into the weeds, in case they get lost, okay? The first thing is this. Now, I'm speaking, by the way, to American citizens outside the United States. I'm not speaking to anybody inside the United States. And Anthony, I strongly suspect that the stuff that you were reading from the IRS in 2009 about, avoid the soft disclosures, I think that was in the context of U.S. residents with hidden offshore accounts. I don't think the IRS was even really aware of Americans abroad, particularly. But here are the things that
you're right. Yep.
Here are the things that that I think people should remember. And if you got a pen, okay, this sort of summarizes, I think, some very important points in terms of, as I understand our discussion today, it's how to think about the problem of compliance, how to think about it, not necessarily the answer, but how to think about it as a problem. The first point that I would make is that Americans abroad really don't have a tax problem. They'll have a tax problem once they start filing, okay? But what they really have is a compliance problem. And by that, I mean how to deal with requirements that are imposed on them that they either, because they didn't know normally, have not complied with, or find out that they have complied with in a way that really wasn't compliance, maybe made the problem worse, okay? The second thing that I want to make very, very clear is what, I understood for the first time why all these articles say get proper U.S. legal advice, proper U.S. legal advice. Well, the reason they phrase it that way is because U.S. lawyers and accountants, as Anthony will know, are subject to something called Circular 230. It's like a code of conduct for, licensed accountants, lawyers, tax advisors, enrolled agents in the United States. And what it really does is, in its totality, we'll talk about this, but is really designed to scare people even more, okay? Because it really makes an objective discussion about the issue impossible, but we'll explore this. Thirdly, I cannot tell you, if you get nothing out of this discussion today but the following, all right, I think that we'll have performed a very valuable service for you. And that is, assuming you're somebody with a compliance problem, you've got to separate the advisor who helps you understand what the problem is and what the solutions might be from the actual tax preparer, should the solution be involving filing tax returns or amended tax returns or something like this, okay? I think that is critically important because it's very, very difficult for, tax preparers, that's what they do. What do you expect? You go to a tax preparer, right? But that doesn't tell you anything about how the issues are identified. There are all kinds of issues for Americans abroad about characterization of things. Is it a foreign trust? Is it not? does this meet the test of being a corporation under U.S. law? You know, et cetera. There's a whole pile of issues that really most tax preparers are not going to get involved in, okay? Next, when I say separate the advisor, in a discussion with Keith yesterday, you know, it's, well, okay, but I mean, you know, so what does that mean? What are you supposed to talk about? Well, in my 2013 post, which is reproduced basically as part C of this post, I identified 11 considerations, 11 separate considerations that people ought to be thinking about before they, you know, pull the plug, you know, so to speak, on the, you know, we're going to do this or that, okay? Fifth, for Americans abroad, there is absolutely no outcome of this that's going to be satisfactory for you. Absolutely no outcome, because of the injustice of the U.S. extraterritorial tax reporting and penalty regime. You're going to be left with either, you know, the outcome is either extreme fear, which is not good because it makes it difficult to make any rational decision, or extreme anger, which is bad for your health in another way. So you have to understand there's a huge emotional component to this. So you need to come in somewhere in a way that you can live going forward. Next, if you're not in the U.S. tax system, coming into the U.S. tax system, in my experience, will probably be the first step towards renunciation, because large numbers of Americans abroad, once they enter the system, just can't maintain it. You know, it's so difficult.
That's true. And by the way, if you've made it streamlined disclosure and fell out of compliance, guess what? You can do another streamlined disclosure. That is something. Is that something that's happening to a lot of people, that they didn't realize that they went through the whole streamlined process? And Keith, that's something I hear you understand that too, because they go through the whole process, Keith, and not kind of like, okay, they thinking because it's so terrible. You might be thinking, okay, this is a one-time sort of thing to do, but no, sorry.
Exactly. You just said what I was going to say before John continues on to number 6. Is number 5. I cannot tell you how many people I've dealt with the mindset that, okay, I'm going to go into the Streamlined program, and they have in their mind that this is a one-time deal. They're not thinking about having to do it every year moving forward. You know what I mean? They think of it as a static action versus a dynamic action that you have to do every year up until renunciation, or just every year. It just doesn't enter their sphere of thinking.
I can see that too.
And just to cap, the final point that I think is important before we, you know, sort of get all over the place here is this, that one of the single biggest problem, in my view, with proper U.S. legal advice is that it, although obviously at the end of the day you're gonna have to get some of it, but it means that you're driven into an advisor who very likely may have no understanding of your tax situation in the country where you actually live. And it is the height of foolishness to see U.S. tax compliance as separate from tax compliance in your country of residence, because rational U.S. tax compliance is in so many ways dependent on understanding what's going on in your country of residence. I mean, this is why Americans abroad have an automatic extension until June instead of April, because I think it's largely in anticipation of the fact that they may need information about tax compliance in their country of residence. Okay, now for that reason, I mean, obviously, you want to find an advisor in the United States, that's you're doing, who understands the problems of Americans abroad. But also consider, I think, the wisdom of finding an advisor outside the United States who also understands the tax system where you live. Okay, but again, you know, for people who have a lot of worry about this, who are not in the system, or who are worried that their returns have not been done properly, I want to go back to the beginning. You don't really have a tax problem. What you have is a compliance problem. Okay, so that's sort of a summary of, I think, the essential points that people need to get out of this discussion today. And let me just punt this back to Anthony or Keith to go in any direction you want.
Well, thanks, John. And I think we got some great comments here. I just want to take a break here, get to some of these great comments that we have so far awesome audience this morning. Thank you so much, everyone, for showing up. This is something that brings up here for Mona Lisa. Is there a Covel agreement, which I believe might be with a K? I'm not sure on that. When contacting an attorney, thought there was more of a risk if initially contacting an enrolled agent. Could an EA in theory threaten to report someone? And that's right. That's exactly right. As an attorney myself, that I would that there's an attorney-client privilege. And as long as their problems are in the past, so that I am not helping them facilitate something, there's something they can disclose to me, and that sticks with me. But it is a situation where you have a CPA and enrolled agent; they're not bound by the same thing. So there isn't. And then the Supreme Court has an interesting way of saying that the privilege doesn't extend to tax prep. They just say it's mere tax prep. That's their argument. Well, the attorney-client privilege doesn't extend to tax prep because it's mere tax prep. And I don't think they actually have taken a look at the returns to say it might be a little bit more than mere tax prep, because the numbers that you put in there are a little bit more than the mere tax prep.
Anthony, if I may ask if you guys expertise on this, because this is where it's a little gray for me. Because let's say I'm an American overseas, okay, and I've not been in the U.S. tax system, and I contact an enrolled agent, okay, to one, possibly get an estimate on what he's going to charge, because I'm going to get 3 estimates and go with the best one. Just by getting an estimate doesn't mean, and obviously I share with that person, I've never been in the tax system and I need to come into compliance and I need to get an estimate of what that would cost. Just by doing that, that person's not compelled of sharing that with the IRS. Is that correct?
No, they're not going to be compelled to share that. There's no requirement that they say. There's no requirement that they do. The IRS does ask. There's really nothing to stop.
Okay. Now my second question is.
But I would want to say this, Keith. Getting free quotes, that might be a good thing for car insurance. That might be a good thing for getting a roof quote for your house. But I would say this: I would not treat your disclosure as a commodity. That is the wrong way to think about it. I would say it's false.
I'm glad I brought it up. Okay.
I would not say it's because you're saying, well, your cost to you have your cost to whoever's going to do this, and then the other cost you have is what's it going to be costing to the IRS, and then also your emotional cost. Those are 3 things, and I would not want to look. And I've seen what other people charge for. I see what other firms charge for their work, and they're basically not doing any of the important work. They're just doing the basic, like, okay, here, we're going to squeeze this into tax return. Okay, throw out a non-willful, and there it is. It's done. Hey, look at that. It's pretty simple. Look, not understanding the consequences and taking, and oftentimes not understanding the disclosure rules, because what it comes down to in many cases, if there is no tax non-compliance, you actually may not need to use the Streamlined Disclosure Program. You may just be able to use a delinquent informational return only, which is much cheaper, and there's no penalty associated. So many times I see that it comes down to the facts and circumstances of that country, as John said, of that country. How is that treated? What is that thing exactly? Again, with so many times in the U.S. system, there is no direct analogy, so we have to use our various legal reasoning to find the right solution for our client, which is lowest possible penalty and lowest compliance cost going forward as well.
So in other words, you shouldn't just do an estimate, treat it as a commodity, and go with the cheapest one, because cheap can be expensive.
Oh my God. Well, not only cheap can be expensive, but expensive can be expensive. So I would say this: I've seen it both ways. I've seen people charge ridiculously low amounts for terrible service, and then I've seen people charge incredibly higher fees. And these happen to be attorneys who charge the higher fees for the worst possible thing ever.
I have too. I have as well.
Yeah, we all, and I think we've all seen. I think on this channel, we certainly know that. Yeah.
So the last question on this point, and then we can move on, is: let's say Mr. American Overseas, who hasn't been in the system, goes to an enrolled agent, and that agent does his U.S. tax declarations, shows it to Mr. American Overseas, and Mr. American Overseas says, pays him and says, "Thank you very much. I've decided I'm not going to submit those returns right now, but thank you." What is the responsibility of that enrolled agent in that type of situation? Do they disclose it to the IRS, or do they just say, okay, no problem, and then that's it? Does that make sense, my question? Because it has come up a number of times for me.
I can't
Wait.
imagine a situation where an enrolled agent on their own initiative would decide to send something to the IRS. They could file basically a whistleblower complaint. That's really what they could do. I'm not sure I've seen a lot of those. What I do see more of is that after you disclose, and this is true for enrolled agent and attorney, is now the sort of veiled threat comes out to say, okay, well, if you don't go with me, what are we going to do here? So that's it's really coming down to it's really used as the fear sledgehammer.
Well, where would
That's
that fear
really
be?
what
Because I've had situations where somebody has gone through the process, okay, before having it formally submitted, they see what they owe the IRS and they've decided, I'm not going to do that, okay? And they just stop, but they do pay the enrolled agent. So where would any veiled threat be in there? Because the enrolled agent has his money, but the client has decided not to file. And I've had situations like that.
Right.
So,
No, I would say, right. In that case, the client dropped off the face of the earth. And then typically that is, but I mean, here's the thing. You paid them money though.
right.
And so they got what they wanted. So why would they go any further? So
Right.
in that case, yeah, they dropped off the face of the earth. Okay, lost client with the who knows what happened to him, right?
Right. And the enrolled agent, his job is done, and that's it. No
That's
problem.
it. Got the money,
Awesome.
and you didn't have to do any work. Yeah. No, we just got a
Okay.
comment here, and I do want to. Mona Lisa says one firm was going to charge me about 75,000 pounds to get into
Wow.
compliance, and I would say we've charged people more. We've
Okay.
charged, depending on the situation. And by the way, and and the reason why they were happy to pay us is because we were half the price of other quotes. So as soon as, and this is, and as what John said. John said, you really don't have a tax issue, you have a compliance issue. And that's right. That's exactly right. And these compliance costs are utterly, utterly insane. You start stacking together years, of multiple 5471s, 8865s, 3520s, 3520As, years and years of these 8865s. I don't know if I said that already, 8858. You start stacking together the most complicated, onerous forms that are designed to be complicated and onerous and designed to be punitive. Each time that the tax code is amended, it's always time and time again, it's some provision in there to particularly harm those overseas with international assets because it's a safe target. Everyone in Congress targets foreign income and they feel great about it. Hey, look at this. We just increased the penalties for this. Hey, look at this. We just increased the penalties for this. Hey, look, we just increased the taxes for this. That is what goes on again and again because it's the softest target. And I think that speaks volumes about the where we are in our tax code.
Okay. Can I add
back
something
to you, John?
this?
Yeah. Yes, please, John.
Yeah. Okay. First of all, although this is completely immaterial, Covel is, I think, spelled with a K. If anybody wants to do something, it's a Covel, Kovel. If somebody wants to search on that, okay. But look, listening to this whole thing, I want to make an incredibly simple, mindless point here. Okay, attorneys generally don't prepare tax returns. Okay, they generally don't. Usually, that goes to a CPA or something like that. And this is, again, I'm preaching the gospel of separating the advisor from the person who would actually do the compliance. Okay? Now, the advisor, some of the stuff you might get is, well, do we need to file a 5471? Do we need to file a 3520, et cetera? In other words, this can be decided, before the whole question of spending all the money for the tax compliance, et cetera. I'm going to say it again. I think the single biggest mistake that I think people make is they see this as a tax problem when it is truly a compliance problem. And compliance, if it isn't evident, means, well, what are the requirements? What is your situation? What do you have to do, et cetera. And also, by separating the advisor from the tax preparer, you're not going to be in this situation at all, where a bunch of tax returns, have been filed, et cetera, et cetera. You won't be into it because the actual preparation is the result of some, considered reasonable analysis, etc. Then Keith asked the question about, is the, say, an enrolled agent, and by the way, enrolled agents generally do very, very good tax preparation work. So we're not disparaging
Yes,
enrolled
absolutely.
agents
Absolutely.
in any way, shape, or form. In fact, that's their sole reason for existence, right? But, Keith asked the question, is there some obligation, to disclose this to the IRS? The answer is, I think, okay, although I didn't consider this before this discussion, is not under the U.S. Circular 230. There's not an obligation to disclose, but there are some countries out there where the professional tax preparation standards include ensuring that people are compliant in all the jurisdictions where they have to file taxes. And that is something that I would research a little bit if I were an American citizen living outside the United States. What are the professional obligations for tax preparers in their country of residence? And do those obligations include, for some reason, a requirement to ensure tax compliance in all jurisdictions where taxes have to be filed? And there is one that I'm aware of, but because I don't want to get into because circumstances change, etc. But I'm aware of at least one, and that is what prompts this. Okay.
Okay. So I hope that answers the question that
Canada is not the one, by the way.
And it's not Canada.
Right, it's not the one.
So we know it's not Canada. Okay, that's kind of my first guess, right? There we go. The requirement is like we cannot assist or advise in non-compliance, and for me that this is where I had a lot of calls with people back in the early teens, and I remember one call I had. This one was a guy who he said, look, I'm living in Russia, and he says it's a $20,000 square foot mansion. Well, actually, Anthony, I'll just be honest with you, it's a palace, and I said okay. And he said, yep. And I had I have about $20 million that I had in Switzerland, and I did not disclose it. I discussed why he didn't do it and didn't have a really good reason for it. So I said, okay, look, this is the deal. If you want to hire, I don't know what your name is, but if you wanted to hire me, all I could do is advise you compliance. And so then what I could tell you is that here's what you're looking at for a penalty. You're looking at about $6 million. That's what you're looking at. If you hire me, there's nothing other than I could do than hand you around that bill along with my bill. And so that there's nothing more I can do. There's nothing, you can't hire me. And sometimes just people get confused. They think they can hire a tax attorney to help them in their non-compliance. And it's not, and there's really not anything in it for the attorney because that's a lot of risk to run. And what's the work that you're doing? So that's really the thing to understand, that you're not going to find certainly something that you wouldn't, somebody you hire say, hey, I want to hire you so I could do the so-called wrong thing. That's something that doesn't make any sense to us. So that's why I like to make sure, I like to talk to people who already know what they want to do, that they know, like, okay, I want to do the compliance thing. Okay, great, because that's what I do. I don't like so much talking to people about, whether they should or they shouldn't. I don't actually like that, because there's things that go into that decision that go beyond just my realm. I don't want to be in that decision, and there's sort of that conflict of interest that I have as well, that I'm trying to beat up on them to comply because, hey, look, that's what I live on, that I don't like that so much. And so what I always prefer is that somebody, people reach out to someone if they're having those questions about whether or not they should come into the system or not. They speak to someone like Keith, who isn't a Circular 230 practitioner. He's not. He's just a global advocate for the American abroad. And so maybe we should just explain that, get to point, Keith, sort of where your role, because this is really the purpose of this video, is to tell people where they should go first. And that,
but Anthony,
yeah, go ahead, John.
Anthony, okay. Look, I just want to expand on what you're talking about here, particularly, on the role of the lawyer. I mean, obviously, you've got the Circular 230 thing on the screen. So, the person calls you, you can't say, well, no, just ignore the, the FBAR requirement or the Form 8938 or something like that.
Yeah.
But, it seems to me, I think that your obligation, okay, your professional obligation certainly would include explaining that when you're looking at something like FBAR, well, the statute is divided into two broad categories, the non-willful and the willful. What are the facts that would support each, right? And then that even in the context of the civil and the criminal, right? Let me back up. It's divided into the civil and the criminal, right? And even in the civil, there's a difference between non-willful and willful. And here are the kinds of facts that would bear on that decision, right? So, I think there's a great deal that, a lawyer who understands the nuances of FBAR law, which is, growing daily, can and probably should do, okay? That will, assist the person, the possible client, in deciding what is it they want to do. I mean, you cannot advocate non-compliance, but you certainly can explore the different dimensions of compliance, right? And what that, might lead to, depending on whether, if it's civil, willful, non-willful, what are the recent decisions, et cetera, et cetera. So, I mean, there's a lot that you can do that I'm not sure that a layperson could do.
I see your point. So we have now. This is where we are right here, John. This is the section, the 230 issue here. We have a little. This is kind of what we're talking about here, and this is the context of a Isaac Rock Society post. In this is here. This is, I think, really important. I just want to read this. Many readers living outside the U.S. who are not IRS compliant have sought advice from tax attorneys on whether they should or should not enter into a lifetime of IRS compliance and what would be the cost. Maybe your tax attorney living in Canada, et cetera, is also an enrolled agent of the U.S. IRS, possibly affecting the nature of the interaction between the attorney and you, the client. What were the options suggested, especially disclosures made to you by your attorney? Attorneys must adhere to the professional and ethical standards of their law societies. And there you go. I think that's kind of stating the situation as it is. Now for us, John, I would just say for us that we do everything here. I have my lead CPA, Michael Mellott, is an expert at international preparation of returns. So it is something that we do, but how it works is that we say, well, how are we going to do this? We have a discussion. We have a discussion about what things are going to look like before we go ahead and prepare anything. We look at it before we go ahead and do anything like that. And anything the client tells us, as long as they're not asking us to engage in a criminal conspiracy to defraud the United States of America, then we are fine. We can do anything. And if it's in the past, we can clean that up in the past. So, John, the next part we have in your blog is sort of the evolution of the compliance landscape from 2013 to 2023. The IRS Voluntary Disclosure Program, that OVDP, was retired in 2018. The IRS they don't really have a new replacement program, but you can still do one. It's just incredibly onerous, and that I actually don't encounter many people who I would advise any voluntary disclosure program to right now. I think people have made up their minds which way they're going to go. Really what's going on right now is mostly everybody falls into a streamlined compliance procedure. The biggest hiccup that I have is that it comes from our own clients, because they will beat themselves up. They will start to reinterpret history as I should have known, and they really want to fall on their own sword. So oftentimes we have to say, look, this is a complicated thing. Okay, this is a complicated thing. You might be a little bit hard on yourself, and a lot of times we have some very high functioning clients as well who can be incredibly hard on themselves. And so it's the biggest hurdle that we often have is convincing our own clients that they're actually not criminals. But the problem I have, and this is really where my rage or my emotions. I don't have rage. Why would I have a rage? This is where I get a little bit upset, because there are tax professionals out there who are exploiting people's fear and only adding on to it. And then what you see happen is a whole disaster of a result. And one of the big things that goes on is that they will enter someone who made some mistake and they didn't have 100% facts on their side. They will enter them into that full program, which is so onerous, so horrible, so punitive. What's the difference between if they catch it? And that's sort of the problem that I have with the IRS as it is, because they hammer people in the voluntary disclosure program as if they detected them. But these are all the people who raise their hand to say, hey, I want to be in compliance. And man, they really come down incredibly hard. And that's why for most people, the streamlined compliance procedures are the most appropriate way. It's just convincing them that what you did, it's like, okay, and sometimes they don't even have the facts right. Well, I didn't even know I needed to file this form. I'm like, well,
Anthony,
you don't need to file it.
Anthony, I think it's important to add something here. Okay. I want to be stronger on this point than you are. Okay. When they got rid of the offshore voluntary disclosure, the OVDP in 2018, what they said was that, well, we've always had the voluntary disclosure program, which they always have had.
True. And that's true. Yep.
Okay. So in other words, it wasn't replacing. Okay. It was just saying, well, we're getting rid of this. And but we've always had this voluntary disclosure program. Now, the difference was the offshore voluntary disclosure program was a pre-advertised penalty deal, so to speak, right? Okay. The voluntary disclosure program has no sort of, as far as I'm aware, pre-prescribed penalties. But here's the difference. In 2018, the IRS made it very, very clear that the only people who should consider the VDP were people who risk criminal exposure. Now, to your point about people calling and saying, well, I should have known this and I should have known that. Okay, now I'm just speaking from memory at the moment. Somebody can look this up, okay? I think I'm right, but I don't want to commit to this in this video. But for criminal liability, it's governed by something called the CHEEK standard, CHEEKS. And what intentional, okay, what intention means in this case is so it's the intentional violation of a known legal duty, intentional violation of a known legal duty. But the emphasis is that you have to know that you're intentionally not complying with a specific law, right? It's not just, well, I intentionally not filed this FBAR, but you have to know specifically about the law. My point is simply this, that criminal liability is a much, much higher standard. There are very few Americans abroad who are in any danger whatsoever of being prosecuted criminally. And anytime somebody says to me, well, I'm thinking of doing a voluntary disclosure, I say normally, you know what? I think that's crazy, and I'm not going to participate in this discussion with you, okay? You want to do that, go talk about this with somebody else. Because, you are so far away from what they mean by criminal.
Yeah, thank you, John. And this is and especially this is what I would say for people who are in the U.S. and perhaps are green card holders who have a bunch of assets overseas that they never reported. And for those who are living overseas who have a bunch of assets they never reported. Here's the thing, you had reasons for those things to be overseas. There were reasons to be overseas. This is not a situation if you are a U.S. person who takes income and shelters it overseas to avoid the payment of income taxes. That's when we start saying, oh, okay, that actually sounds criminal. But for everybody else who has assets and income overseas, the rules are so complicated. I mean, it's so complicated. And if you listen to this podcast before, you know this story. That I talked to a group, this was years ago. This is probably 5 years ago. I talked to a group manager at a local IRS field collection agent. And I just asked her, how are your offshore audits doing? She laughed and she says, well, Half of my auditors refuse to do them. And now here's the thing: she can't fire them because there's a shortage of auditors. So the auditors kind of, that's her problem. Like, well, if I fire them, now I lose their firepower for the domestic audits. So I might as well have them, and the ones willing to do the international audits, I'll have them do that. So I understand why she just lets them call their shots. I said, well, okay, well, why are half your auditors not wanting to do offshore returns? Her answer was this: because they're too complicated. So that is what we're really looking at. That you have tax situations that are too complicated for your average IRS examiner, and so that's the lens you need to examine your own self, your own actions through. It's like, well, geez, if this is just too hard for IRS examiners and they just are going to say nope out on this, then what standard should you look at your behavior as? And that's where, for most of our people, and I would just say that the voluntary disclosure, I can't think of a situation where I actually would enter someone in. And there was a voluntary disclosure program before that. I did one or two prior to that, just regular voluntary disclosures. They involved Ponzi schemes. And there was no, it was just a way to actually avoid criminal prosecution. That was really the issue. We did 6 years of returns, paid the taxes and some penalty on that. There was no additional penalty on top of it. So now what they do in the voluntary disclosure is that they have the same thing, but now they could just penalize you. And typically they're going to look for that maximum FBAR penalty of 50%. That's what they're going to go with, which is the same amount of penalty you would get if they detected you in an audit on your own. So they treat you, you're penalized exactly the same as if they found you. The only thing that comes off the table would be criminal charges, which for our clients, they're just a million miles away. They all have reasons to do it. And really the first people who did come 2009, those first round of people, they actually were doing it intentionally. And they looked at that deal in 2009 and say, oh, just pay a 20% penalty in my years of tax evasion and pay 20% and 6 years of taxes, just 6 years, not 8 years, 6 years of taxes and a 20% penalty. And all the tax evasion that I've been doing for the last 20, 30 years is forgiven. That's a smoking deal. I'm going to take it. And a lot of them did. So it's really, who gets caught up in this are the people who are doing things least intentionally. They weren't paying attention. But the people who were, they were paying attention. They were like, yes, I think I want to sleep at night now. Let me take care of this right now. So that's kind of what's happened over the years because it's been so difficult it's so difficult to explain to people that they're actually not criminals. And it's so easy to convince somebody they are so that they go into a program that's not appropriate. And these are the heartbreaking cases for me, by the way, because I still have them working and they're heartbreaking. Some of the best clients I have, their previous counsel dumped them into an offshore program with a penalty that's ridiculous. And in these cases, I'm looking at these people, I said they should have been streamlined. Their penalty should have been 0% or maybe 5%. But unfortunately, they dialed the wrong number when they were looking for help, and they lost that lottery. They dialed the wrong number, and they got someone who wasn't necessarily looking out for their client's best interest, but their own.
Anthony,
wow.
Anthony,
go ahead, John.
You're 100% correct, and this is the shocking thing about this, that the OVDP, OVDI stuff really was a truly great deal for, somebody who is an intentional or reckless tax evader. Okay, it really was. It
was. Yep.
The problem was that for Americans abroad to enter that program could conceivably result in a confiscation of, up to 50% of their net worth, right, depending on the circumstances. So on another level, right, we can see this as an example where, Americans abroad were fundamentally discriminated against. Now, in 2012, when the first version of the Streamline came out, there was some pushback from that, I think, and it was a better opportunity for Americans abroad. But there's absolutely no doubt, okay, that the more willful you were, the more your mindset was U.S. tax evasion, the better the OVDP program was for you. There's no doubt about that. And there's no doubt about the fact that Americans abroad who entered it, it was unnecessary. It was incredibly punitive. And I mean, I know of people who, were basically permanently damaged psychologically and emotionally by it. So, I suppose for those people who think that, this is some kind of commodity thing, just call somebody up. Boy, are you wrong.
Right. I actually had to stop somebody from proceeding and entering that program.
Thank
The
you,
voluntary
Keith.
discourse, because, and this was someone who was the typical accidental American, and he contacted a very well-known global law firm that people would know if I say the name, and they immediately said that he needed to enter this program, and they started the process. At the end of the day, I told him to stop, and he did. I saved him $50,000, and he's still to this day very grateful. They were going to put him in a program that he had no business getting into.
Wow, Keith,
Yeah.
thank you for that. That's amazing. And Keith, and this is where maybe we should have you speak a little bit, because if you've been a fan of this channel, if you've been watching us, you know that we often ask people to, hey, first thing to do is to reach out to Keith if you're thinking about doing it. Maybe not maybe not me, maybe not John, but reach out to Keith so he can tell you what reality is on the land. We give people your email to reach out to you right here.
And I tell people, I'm not a tax compliance professional. I am not a tax attorney. I say that right up front. What we do is we lay out and we explore all of the options. And not only explore, we look at the pluses and minuses of each of the options, and do a risk assessment of the options. And it's up to that individual or couple or whomever it may be to decide what they want to do for themselves based on their particular situation. That's it. But I deal with the reality on the ground and not the scaremongering. That's it.
Right. And what I think I really love is what other people are doing. You have a real pulse on what reality is, and you manage a group on Facebook which has 9,000 members now.
Yeah, we're just a little bit shy of 9,000. Yeah.
So you're well informed, and I think that and that you have been and you are. You are an expat. You have the mentality. It. That's how you got into this. I've
been in the States for a little bit dealing with elderly parents, but I do have a dog in the fight because I'll be returning to France eventually. Yeah, I have a dog in the fight.
And that's absolutely right. And we see the outrage. So what are some of the other things that so Keith, I said, so someone gives you a call or they email you, you guys decide on a time. So what are some of the things that come up during these calls?
Oh boy. The one thing is there's no cookie cutter profile. Everybody's situation is different. There are people who have been in the system and then stopped being in the system, whether that be 5 years ago, 10 years ago, 30 years ago, 40 years ago. We have people who are the typical accidental Americans who've never been in the system. There are people who want to renounce and they don't know the best way of going about renouncing. And then when we sit down and talk about it and realize that they're going to be getting a particular complicated inheritance from the United States, that renouncing in the immediate is probably not the best option. But I present all the options and the pluses and minuses for each of them. So everybody's situation literally is very different. So it's really hard to say what is the typical. I think the one common thread is when people contact me, they just don't know what to do. They can't organize their thoughts. And I kind of present it like a Venn diagram. If yes, go here. And I always use the analogy is that this whole situation is almost like a fine-tuned Swiss watch. The proper gears and levers need to come together for the best possible decision for you. It might not be a great decision, but it's the best possible decision vis-a-vis this fakakta, if I may use that term. And people who don't know it, it's Yiddish for messed up U.S. system. And we just go from there.
Right. Well,
and
you
talk
know,
about the
John,
different
John
options.
has John has 11 considerations to help formulate it together. So maybe we should
Yeah.
just go through. Why don't we go through these?
Well,
Let's
exactly.
do
I
it.
was using my own,
Yeah.
but now John has brought to the
So he has a
forefront
great, a
his,
great formula here. So let's go over to
yeah,
John's, John's formula. So first
yeah.
one is, and he has no pun intended on this because it is absolutely terrible. Puns are the lowest form of expression possible. So I appreciate that. Investigate the current condition, the state of your U.S. citizenship. So, you know, you want to find out if you're, you know. So John, what do you mean by this here? What's our?
Well,
what are we
I
looking
mean
for here?
two things. Okay. So the problems with this really started at two points in history. In 2004, where the Internal Revenue Code was amended to create what I would call a separate kind of U.S. citizenship that I'll call tax citizenship. And in 2010, of course, the FATCA thing where, you know, the banks got involved in trying to identify U.S. citizens. Now, although there's not universal agreement on this, it does seem to me, so now the difference is this, okay, prior to 2004, if you lost U.S. citizenship for nationality purposes, you also lost U.S. citizenship for tax purposes, okay? Now, although there's not universal agreement on this, okay, concerning retroactivity of laws, etc., the first point I would make is that those who have committed a relinquishing act and believe they've lost U.S. citizenship, of which there's a very large number out there, and who have not behaved as a U.S. citizen, may be able to take the position that they are not U.S. citizens, even though they don't have a CLN, okay? Now, I fully appreciate from anybody listening to this that there are law firms that would disagree with me on that. I think they're wrong, okay, for reasons that if somebody wants to email me, I'll send you a post I wrote on this. But, you know, that is a possible defensive angle to this. Now that particular defensive angle finds expression, interestingly, in the FATCA IGAs, all of them, that where the banks either have to be shown a certificate of loss of nationality or a reasonable explanation why they're not a U.S. citizen, even though they don't have a certificate of loss of nationality. And this is where, you know, this point, you know, very often fits in very, very well, because it can also solve the FATCA problem. But, okay, this is extremely nuanced, okay? And the FATCA IGAs are actually different. For example, the UK one speaks about renunciation, other ones speak about relinquishment. In any case, that's my first point. Second point, emotional considerations are as important as tax considerations. Oh God, you know, I mean, there's a difference between responding in life and reacting, and you sure cannot be reacting to this stuff, okay? You have to be grounded enough to respond in a rational way. And this is why, you know, again, I keep preaching the gospel of separating the advisor from the tax preparer, okay? I mean, all a tax preparer is going to do is, whoa, let's file, you know, etc. But I mean, this is really about getting your life back for lots of people. You know, the tax thing is not the issue. It's a life, quality of life issue. It's how to go forward in life issue.
It is.
You know, that's what this is really about, right?
It's one of their greatest. It's one of their greatest traumas that they're going to have. It really is.
Absolutely. I mentioned this a minute ago, okay, but you know, there's a difference between responding to something and reacting. Reactions are things you do, you know, at the last minute when you really haven't had time to think, or can't think. Responses are things that you do, you know, which are generally based on some kind of objective analysis of what's going on, made over a period of time, and, you know, hopefully with finding some kind of advisor who you trust. But take your time, okay, in this whole thing. 4, I mean, obviously, okay, any response requires that you investigate possible U.S. tax liability. Now, you know, people who might say, well, you know, so why don't I just go to an accountant? Well, because there are certain things that you can know, right, just based on your sort of financial business life profile, that, are the types of triggers that may create U.S. tax problems. Notice specifically the controlled foreign corporation issue and the transition tax, et cetera. I mean, these are things that, that you can have a conversation with somebody about in advance, okay, to see what might be going on. You don't have to know the exact numbers to know whether there's a possibility of U.S. tax liability, right? Or, sale of a house where the capital gains exempt in, one country, not another, et cetera. Okay, so, continuing on down there, down to 0.5 or whatever. But I think you should take steps to figure out where the soft spots, the pressure points might be that, might result in owing tax, right? If you sold a principal residence, how long ago was that anyway, right? I mean, how many years are we coming into compliance for, et cetera? Next one, 5, you understand your U.S. tax compliance options. Now, this I updated a little bit because OVDP is gone, but,
As we talk, yeah.
But I mean, here are your options, right? It seems to me, the first would be to, if you want to continue going down there, Anthony, would be to use the Streamlined program, or perhaps the relief procedures for former citizens if you're looking at renunciation. But you can also refile past returns without using one of those programs, depending on what's going on. Or third, you didn't know about any of this stuff in the past. Just clean up your life and file on a going forward basis properly. I mean, look, these are logical options, and these are the types of things that are worth having a discussion with somebody about. Okay, but I mean, it's not like, it's not like there's only one way to fix U.S. tax compliance problems, and I think some would make more sense than others, depending on what your situation is, right?
Yeah. One thing I just
Next
wanted to point out, there's a comment here from Melvin. Because jumping into this one size fit all, you could fit into extreme penalty exposure for totally non-willful behavior, and he's absolutely right. It's mind-boggling. And one inadvertent mistake, and for instance, old age and dementia sets in, and this is what is absolutely horrific. This is what's absolutely horrific. When you see the volume of cases that I do, and when you see who the IRS goes after the hardest, guess who it is? Old age and dementia. They do it intentionally, and it's utterly sickening. So you got to watch out for them. They're not on your side, and the tax. And again, you could have. And I think our whole point here is that your tax professional may not actually be on your side, and that's what we're trying to get to. It's like you're going to them when they will be, because you've done your homework, and that's what this is about here. Doing your homework to say, yes, I do want to talk to someone because I understand what they're going to have to say to me if they're ethical, and then I know what they may say to me if they're trying to close a sale. So go ahead, John.
A number of years ago, I read an article that I found absolutely astounding. It was, obviously for the compliance industry, but the article was asking the question of whether dementia would be grounds for reasonable cause for penalty abatement. And I took one look at this and thought, oh my God, I mean, these people have just completely lost it. I mean, to even ask a question like that, I mean, there's two ways of looking at it. Either the people who are asking the question are so disconnected from reality that you probably shouldn't involve them in what you're doing at all.
Yeah, that's a scary question. Like
the second is,
question is scary.
But the second is, it is over. Okay, those who can renounce should renounce, because, if anybody jumped into this discussion and listening to this right now, I mean, are you seriously telling me that compliance failures that result from dementia would not be reasonable cause? Well, I know how certain tax compliance lawyers or accountants might answer that. You know what they'd say? Here's exactly what they'd say. They'd say, well, look, buddy, you should have known that you might suffer from dementia. You should have known that in advance.
Yeah.
I mean, this is in a sense what you're up against, right? But it
Well,
also
we also had a client who was in a coma. He was actually in a coma.
No.
Yeah, no,
Really?
and they
Wow.
like, no, that's not reasonable cause. That's what you're dealing with.
Well,
You're joking.
no,
They
no,
said
I am
that.
I
No,
am
he's
telling
not
you that
joking.
we eventually prevailed, but it took a lot of money and time to eventually
Wow.
prevail. But that
You see-
is how ridiculous that is how ridiculous this is. That yeah, so what? So what? So what? You're in a coma. We're sorry for you. Good speedy recovery to you. But here's your penalty.
you should have done this in advance, anticipating that maybe you'd be in a coma, right? But
You may be
what
in a
this
coma.
really is indicative of, to move away from the specific examples that are horrific, is a country that is so that has so disabled itself by blind adherence to law, right? That they no longer can evaluate anything in context, and that's the problem that you've got here, right? I mean, it is a serious problem, and I don't know what to do with it. I mean, I think the best thing is probably not to be an American citizen, to be brutally honest, unless you want to live in the country. Move up to 6. What was 6? Did we miss 6?
Yeah.
Oh, yeah.
Oh, you
I mean,
terrible Canadian. You inserted your Canada propaganda in here. Hey, we're talking about the world.
No,
here,
we can change it to UK, or any other country. I mean, the point is that, anything you do in the US, is going to affect the situation wherever you are, right? I mean, anything you do is going to have some kind of a tax a consequence, right? Both where you live and in the United States. And you need to be aware of that. I wrote this originally from a Canadian context in 2013, but we can put in country X if you like.
Yeah. So we're on to number 7 here.
Decisions are not, in this context, are not like we get to a mathematically correct answer. It's what would I prefer to live with, going forward, given that, which leads us directly to 8. You're not going to be happy with any course of action. I mean, you do nothing, you run the risk, at least this is your perception, you run the risk of being discovered. You attempt to clean up past problems. Well, that can be very, very crippling. Going forward basis, I mean, there are people who, will look behind them. I mean, what I would say is this, that none of these things are either right or wrong, but whatever you do, don't look back. Don't look back. You've done the best you can.
That's right. Yeah. And
9 is probably the most important.
We didn't create this system. This is not something that we're responsible for. We didn't create this. We didn't ask for this. We didn't want it. Nobody wanted this. And it's really just, again, it's Congress again and again when they're looking for, free revenue to offset their other spending. They just say, oh, we'll pass this law for people with foreign income and assets, and we'll make money. We've seen it time and time again. The big one was FATCA. FATCA was going to be a revenue raiser for the U.S. Treasury. Guess what? It didn't turn out that way. But guess what? FATCA is not repealed. Just because those revenue offsets that they said were going to happen when the law was passed never happened, it's not a reason why the law should be repealed. That would be good if that actually could repeal. If the revenue offsets don't happen, that the law would be repealed. But that would assume we live in a representative republic with.
Anthony, almost all of these rules that affect Americans abroad have come in as revenue offset provisions. Okay.
Yeah, exactly.
Et cetera.
That's just a big lie. So I love what you have here. Do you prefer to live with anger and anxiety? Right. Choosing among compliance options is largely about choosing among emotional outcomes. Well stated. Yeah. Do you prefer to live with anger or anxiety? And I think that's what you're left with. If you do it, you might have anger, and if you don't do it, you might have anxiety. So you know what? A lot of people choose anger over anxiety. Anxiety can often be the worst thing because that's the thing that might get you up at night. Anger probably won't as much because you're tired of being angry all day long. But that's what comes down to.
Anger is very corrosive, Anthony. It's very corrosive.
They're both terrible. So
yeah, they're both terrible. I mean, this is the reality. if you live life as an American abroad, it's necessarily terrible, okay? You know, if you're going to try to be compliant. That's the bottom line, okay? Which is why all roads lead to renunciation. Next.
You can, yeah, right on.
All right, reality, this may be a little overstated. I wrote this in
come
2013.
on.
But,
Yeah.
you know, you can decide yourself. I mean, you listen to the conversation today. I mean, at the very, very least, under 10, it's pretty clear that the advisor matters, okay? And matters hugely.
Well, what
And
I
there's
would
a
say, what I notice when you say that, understand they are working for the IRS but being paid by you. There's some truth to that. And where I find it really, really common is when you get the ex-IRS legal counsel, somebody who did work for the IRS, because you go to them and say, oh, they must have some special favors that they can get from me. Well, you got to understand, the favors work the other way too, because their friend on the inside may, hey, look, I really need this penalty here in order to get this case closed, and then I can maybe get that promotion. So it works both ways. They could actually be working. They can be working for the IRS. So be careful of that. Someone who you're hiring someone because of a perceived inside track with the IRS. If they do have it, if they actually do have an inside track with the IRS, which certainly can happen, it also can work the other way, which may not be in your interest. So just look out for you. I don't look at myself as working for the IRS. I'm looking at it as sort of trying to protect my clients the best I can from what it is. That and taking every interpretation favorably to the client. That's and I think that's what you really want. Someone who's not going to look at the IRS.
I think, you know what, let's amend that paragraph. Okay, understand that. First of all, let's put in parentheses, except Anthony. Okay.
and John. Okay. There we go. We have a couple exceptions here, right? Yeah.
Maybe say, instead of they're working, as a general principle, okay, because of their Circular 230 requirements, they're generally trying to give advice that's compatible with IRS directives. Okay, how about that?
There you go. That's beautiful. Yep, well stated. Well stated. Yep.
Okay, so there we go with that.
No, don't we have 11?
Yeah, there's an 11.
Oh, and lawyers and accountants cannot tell you not to come into compliance. Yeah, exactly. That's what I can't. Don't ask me that. Don't ask me that, because and by the way, I always have to assume that the person I'm talking to is actually a Fed and is recording my conversation. So that's how I work. So I'm never gonna don't look for me to advise, and that's kind of the safe way to be, because I'm sure they would love to take down somebody, take him, hey, look, I was trying to help somebody and I gave him this advice, like, great, this is what we have, and now things are going to go. So I always have that in the back of my mind, that my conversation is being recorded and that the person I'm speaking with could be a federal agent.
Look, no lawyer or accountant is ever going to tell anybody to not comply. Okay, I think that's fairly clear.
Yep.
11. This actually may be the most important. It's funny. I wrote this 10 years ago, but other than some modifications.
This part 11 you did as well. You wrote 11. What? You wrote paragraph 11 10 years ago.
Yep.
Oh, my.
Coming into compliance.
Wow. Well, you are clairvoyant.
This is the wisdom of not living in the United States, Anthony. Coming into compliance will solve one problem, will create another possibly bigger problem. There are two kinds of U.S. citizens abroad who have problems. A, U.S. citizens abroad who are not compliant with U.S. tax laws. Well, depending, maybe, to the extent that they worry, etc.
Right.
I don't know. But listen, they have a problem. The second group are the ones who are compliant with the U.S. tax laws. I'll give you an example. Recently, somebody called me and wanted to come into compliance. And,
yeah.
And I don't do tax preparations, presumably, So I sent the person off to we talked about it. She wanted to do a streamline. So I, sent her off to somebody to manage the streamline process. And ever since then, she's been getting, every couple of weeks, a letter from the IRS. It's unbelievable. And it's just the nature of the beast, right? I mean, this is what U.S. citizenship is about. Taxes, forms, and penalties. I mean, U.S. citizens are card-carrying members of the greatest tax, form, and penalty club in the world.
In history,
I mean,
the worst
in history, it's getting to the point where
and nothing is close. Nothing is as bad.
I mean, I think what we should do is, why don't we host a New Year's Eve IRS Medic podcast, and we can invite people to call in talking about their year of penalties and letters from the IRS. I got this, I got that.
And you bring up a great point, though, because what happens is, well, what if you did do your disclosure, but now that because you filed, for instance, and this happened a lot for a lot of our clients who use the Streamlined Disclosure Program because they had a foreign trust that they had to report, or foreign gift, and there's a 3520A or 3520, we reported things correctly, and the IRS assessed them $10,000 penalties.
That's right, really for late filing.
And a whole,
exactly
not just
right.
And it was a nationwide thing. So a whole bunch of people who did it correctly got assessed penalties. Now our clients, we got those penalties removed, but I got to imagine there's people, who just were advised to pay it. What was that about? Why did I enter this program to avoid the penalties when you were going to penalize before? So that was a glitch in the IRS's system that they tell us they fixed. So
let me tell you something that's not a glitch. That's even worse. Let me tell you something that's not a glitch. Okay. So there's a group of people who do not live in the United States. Their parents are not American citizens. They just lived outside the United States. And what typically happens is that, the parent will leave this technical U.S. person, a piece of real estate or some assets or something. And Anthony, you're well aware of the reporting foreign gift requirements, or rather, not foreign gifts from a foreign person, a non-U.S. person, if they exceed $100,000. Off the top of my head, I believe the penalty is a third of the value of the thing.
30%. Yeah, I think it's 30%.
All right. So what has happened is there's actually a group of people who, learned about this, learned about it late, filed the form 3520 late, apologizing, I had no idea of this law, and were rewarded with 30% penalties. Okay. So, this is a very, very serious problem, leading to the question, of this. Should advisors be telling people that, well, as a matter of course, because you didn't report this on a timely basis, if you report it, you're going to assume you're going to get a 30% penalty, which you'll then have to pay a lot of money to try to get abated. Okay. This is unfortunately the reality of a tax system that attempts to claim the residents of other countries as U.S. tax residents, and that is heavily, heavily dependent on a ridiculous penalty regime, right?
Right. And then,
anyway,
on your 3520, and that's really the problem that I have as an advisor is, okay, here's how we're going to do it. We're going to do this, but by the way, the IRS may just penalize you anyway, because now they know you had to file it, and it was just their error. Or maybe it wasn't their error. They just want to look at it as a penalty. And that is something that has to go into it, before you just don't assume that just because you did everything correctly, that the IRS is going to do
that's exactly right. There are two kinds of people that the 3520 people will penalize: those who've done it correctly and those who haven't. So, this is an incredibly serious problem, right? Incredibly serious problem. Fortunately, the good news, the taxpayer advocate has recognized the insanity of this and has written some very, very good blog posts over at Tax Connections exposing this. But, unfortunately, it is what it is. Okay,
indeed. So, go ahead, John.
Summary and final two thoughts. Okay, this is 2023 based on rereading my 2013 stuff. Well, educate yourself and consider the 11 points in Part C before involving tax cross-border professional. But here's the second thing, okay? And I want to pause for a minute. I don't know how many people are listening to this, but God, I hope this sinks in. Okay, I really hope it sinks in. Okay, now listen to me carefully. This stuff is incredibly confusing. Okay, and when people read this stuff online, they go online, and you know what they read are little clips here and there, right? And one of the clips that you'll read is, well, you shouldn't own PFICs, for example, so sell them. Well, I've got to tell you, okay, that the solution to this may very well be to not sell it, okay, because you may, by selling it, trigger a massive excess distribution that, you know, could confiscate a large part of the capital. So one of the things you need to, as part of the, you know, sort of detective research process here is, what would happen if I sold this stuff? Okay, I mean, you need to be extremely careful with this because there's so many moving parts. It is so nuanced. Now, having said that, I mean, I've been through this with people before, and it's always the same thing. Well, you know, I read this online or I read that online. What you're reading online is focusing on one moving part of a much broader problem, okay? And what you need is to analyze that one moving part in the context of the whole. Now, in my experience, I've tried, you know, hard, okay, to make this point, and I have never successfully made it, so I will assume that people who just heard that are not taking it seriously, but you ignore that at your peril, I assure you. Anyway, that's all I've got to say.
Well, thank you. By the way, if you want to reach John, here is his email address, citizenshipsolutions@protonmail.com. Want to reach out to him? Got to turn over to Keith for his final words, as he's the one who is really the one we want to talk about here, because you're often the person. So, Keith, what would you say to people who are thinking about who have an issue? Maybe they have a streamlined disclosure that maybe wasn't right. Maybe they got a penalty letter. Maybe they're thinking about renouncing. So, what should they do here?
I would say let's have a talk. Let's have a
There it
talk.
is. I think that makes a lot of
Let's take a look
sense.
at your options, and it may be that they need to go to John, or they need to go to Anthony. It just depends on their situation. But let's talk.
There you go. I appreciate that. Now, you know, one of the things that, as I've been reading, as I've been learning more of these terrible things, and it was an article that you sent me last week, John. I can't remember which one. There's so many articles. It was an article I was reading in response to some collections, a case that I'm working on a fantastic client. And as I read the article, and the article was going over how 5471 penalties and some of the other ones may not be the thing that the IRS can use their regular deficiency procedures. And the article went over the history of all the tax code changes from 1960 onwards. And I noticed that in every time the tax code was amended and reformed, that the tax code specifically made something terrible for Americans overseas. And again, as we discussed earlier, it was claimed as a pay-go offset.
Yep.
And so, you know, I know we said, you know, that they don't care that they don't care. That's been one of our constant statements here that we've said about the IRS and the way that they're punitive. And we have to understand why. That a dynamic that goes into it, and it's precisely why. It's precisely why that the Americans overseas and those with foreign assets are a political target. They can be politically targeted with zero repercussions, and in fact, a lot of people say, "Oh, good, you got those tax cheats doing it," and that is really what you're up against. You're up against a mob of ignorance and hatred. That's what you're up against if you have things overseas. And that's why it might be something to think if you do plan on living overseas. Okay, as bad as it is right now, okay, how bad will it be next year? How bad will it be the year after? You thought it was bad in 2001. You thought it was bad in 2011. It's getting worse and worse and worse. And so John, who I didn't necessarily believe him when he first said this, he said all roads lead to renunciation. And I would say, well, that might be sooner or later. It is something where you live overseas, the U.S. income tax code is making your life impossible, and you're well aware of that. So it might be something you need to do. And to renounce correctly, that also starts off with probably getting in the last 5 years of returns filed. But again, that might not be something to reach out to me. I will share my email, aparent@irsmec.com, if you have any comments, questions for me, or if you're thinking about being a guest, or if you are looking for a job. We're always hiring enrolled agents, CPAs, and attorneys. So you always can send your cover letter resume to me. However, if you are thinking about all roads leading to renunciation, you might want to reach out to our good friend, Keith Redmond, global advocate for the American abroad. Again, at his email to get the ball rolling, to talk about your issues on that personal level that we all deal with things on. So with that, we had incredible comments, incredible audience reaction, a fantastic large audience today. Thank you so much, everybody. By the way, guess what's coming up next Tuesday? We have a live podcast planned. Yeah, I'm like, whoa, it's
coming up fast.
It's coming up fast. So if you are watching, be sure to if you're not subscribed, turn on those notifications, because we're going live. Because next Tuesday is going to be our live stream of the more oral argument, where with the transition tax, where this is the reason why we're seeing a lot of media, all the esteemed academia, flipping out that the Supreme Court may actually rule that in order to impose income, you have to have income. So this is going to be something incredible. So we're going to be listening to the live stream and commenting it on. I'm not sure what time we're going to get going yet. I think probably 9:30. We may get going a little bit earlier. So again, be sure to turn on that notification so you know when we go live. It should be an incredibly robust discussion, and this is where we all can come together. This is a safe place where we all can come together to talk about the truth, the absurdity of the U.S. tax law, and especially how it cripples people overseas and those with income and assets overseas. With that, I want to thank John Richardson, Keith Redmond for today. This is Anthony Parent of IRS Medic. I thank you for watching.